Welcome back to the second segment of Contract Law Consideration. We ended the last segment looking at some rules which govern consideration. Now I will just carry on in that vein and look at the remaining rules as it relates to the governing of consideration. Now, consideration need not be adequate, and the point here is that adequacy is a question of fact. You will see we'll look at sufficiency as well, but that is a question of law. Consideration need not be adequate. Adequacy is a question of fact, and it need not be equal in value to whatever the other party is giving. So it is for the parties themselves to arrange their own bargain. So if you decide that I am going to give you a mountain bike and you give me a peppercorn, for example, as far as the eyes of the law are concerned, that is adequate consideration from both sides. Now, the case that makes this clear, of course, is the case of Chaplin Nestle in 1960. The claimant owned the copyright in a dance tune called Rockin' Shoes. Now, a firm called Hardy & Company made records of it, which they sold to Nestle for 4 pence each. Nestle then sold them to the public for about 1 6, which is old money, plus the wrappers from 3 chocolate bars. Now, these were immediately thrown away once they got them. Now, the claimant claimed a royalty, and the case turned on whether the valueless wrappers could be part of the consideration. It was held that even the most worthless items can be good consideration. So a contracting party can stipulate for what consideration he chooses, and it says a peppercorn does not cease to be good consideration if it is established that the promisee does not like pepper and will throw it away. And that was Lord Somerville's remark, of course. Trifling consideration in Delabere and Pearson in 1908 was held valid consideration. And so the point, of course, is if you and I have agreed what will be consideration, then it is highly likely that the courts will certainly hold us to that. Now, the other rule governing consideration is that it must be sufficient. Sufficiency of consideration is a question of law, and the consideration must have some value in the eyes of the law. Now, traditionally, there are certain things that have no value as far as the law is concerned. Now, if you promise to perform an existing public duty, so for example, you're a policeman and I am going on holiday and I say to you, can you make sure you keep an eye on my house as no one is there? Well, you are already under a public duty to ensure that there be no criminal activity around where I live. But if you and I make that agreement, then I can turn to you and say, well, you have done no more than the public duty that you're supposed to. Well, this is what more or less came to a head in the case of Collins and Godfrey in 1831. Godfrey was involved in a lawsuit and caused Collins to be subpoenaed to attend court. Now, Godfrey offered to pay Collins 6 guineas as an attendance fee. It was held that as Godfrey was legally bound to attend anyway, it was not good consideration to do so. However, if you do more than your duty, so go back to my policeman's case. Let's say I've asked him to park his police car and go round to the back of my house through my side gate and check for me each night. Then am I asking him to do more than his duty? Well, again, this felt to be considered in the case of Glassbrook Brothers and Glamorgan County Council. This is a 1926 case where during a miners' strike, the colliery manager James requested that the local police superintendent Smith provide extra forces to protect the working men against the strikers. Smith thought that the men were adequately protected by the policemen already on duty and those that were already available. But on James's insistence, he provided an extra 70 who remained on the premises until the end of the strike. Now, the colliery owners were then sent a bill for the extra policemen, which they refused to pay on the grounds that the police were only performing their legal duty to protect the public. The court said that although the police cannot accept extra money for doing their normal statutory duty, when special services are required beyond the normal call of their duty, they are entitled to be compensated. Now, an interesting case in 1956, of course, is Ward and Byam. When the parents of an illegitimate child separated, the father promised to pay the mother £1 a week, provided she looked after the child well, and that the child was happy, and also that she's allowed to decide for herself whether or not she wishes to come and live with you, he says. He later refused to pay the money on the grounds that the mother was only doing what she was legally bound to do. The Court of Appeal thought that he should continue to pay, though the judges were not agreed on the reasoning. Lord Justice Morris thought that the woman had provided extra consideration by keeping her child well looked after and happy. Now, Lord Justice Denning, for his part, thought that a promise to perform an existing duty was good consideration anyway. Now, the fact is that sometimes it is difficult to see through the veil of Ward and Byam, but one can only imagine that, as far as the court was concerned, it was one that they thought was necessary for them to find as such. Because if you go back to what we had looked at in terms of intention to create legal relations, we see a social context here which arguably in the general main would negate against such kind of finding. But in any event, that's the view the court was of. Now, a promise to fulfill an existing duty owed to the same person. Now, this is one which will give the most, or rather the main basis for an exam question on consideration. If you get an exam question on consideration, there is every likelihood that this section is what you need to discuss. And it is about the fulfillment of an existing duty which is owed to the same person. So I ask you, for example, to paint my house. You start painting my house on Monday. You and I had an agreement that you would try to get it done by Friday. By about Wednesday, I'm not so sure you're going to finish on time. So I offer you extra money to make sure you finish by Friday. Sure enough, you finish by Friday. Are you entitled to that extra money, given that on Monday the agreement was that you ought to have painted? Well, if you look at the cases in history, we can start with Stilk and Merrick. And Stilk and Merrick said that performing an existing contractual duty was not consideration for a promise of extra money. Now, this was confirmed in the case of the Atlantic Bar in that point. Now, if more than had originally been promised is performed, then there is consideration. And the case, of course, is Hartley and Ponsonby. Now, let's see what the difference is. Stilk and Merrick is an 1809 case, and Stilk was contracted to work on a ship which was owned by Merrick for £5 a month, promising to do anything needed in the voyage regardless of emergencies. Now, after the ship docked at the destination, 2 men deserted. And after failing to find replacements, the captain promised the crew the wages of those 2 men divided between them if they fulfilled the duties of the missing crewmen as well as their own. Now, after arriving at the home port, the captain refused to pay the crew the money that he had promised them. Now, the defense argued that on the basis of Housen Watson, where it was decided that no action would lie at the suit of a sailor on a promise of a captain to pay him extra wages in consideration of his doing more than the ordinary share of his duty in navigating the ship, and his lordship said that if such a promise could be enforced, sailors would, in many cases, suffer a ship to sink unless the captain would accede to any extravagant demand they might think proper to make. The lawyers for the plaintiff attempted to distinguish this case from Housen Watson by pointing out that the circumstances were entirely different and that the captain had offered the extra money without any pressure being brought to bear by the crewmen. Now, the courts, of course, were not having any of it. And what we will see is that when you look at the later cases, and indeed when we get to the seminal case that really deals with this era, when we look at Williams and Ruffy, we will see that there is a tendency to resile from the whole background of Stilk and to confine Stilk to a period in time when you had very unsavory characters who would certainly more or less hold you to ransom, and as a captain you'd need to get your ship back. So Stilk and Merrick, court said that they would not allow the claim. Now, in the contrasting case of Hartley and Ponsonby in 1857, we see a ship which left England for Bombay with a crew of 36, but by the time it arrived en route to Port Phillip, only 19 people remained. Well, 19 seamen, sailors were there, and only 5 of them were able seamen. Now, the captain offered the remaining able seamen an extra £40 for completing the journey. Now, it was held that the seamen had provided good consideration, as what they were now being asked to do was different to what they had agreed to do when there was a full crew. I think the point to be made here is when you look also at Stilk, you see it's only a couple of people who've deserted. When we look at Hartley and Ponsonby, you are looking at practically half of the crew who's left, and you've got 5 able seamen who are able to carry this through, notwithstanding that there's this ragtag navy with them. But the fact is, certainly, you can arguably see a difference between the two cases. Now, modern commentators say that the decision by the judge not to award the money to the plaintiffs was based at least, well, in Stilk, was based at least partly on public policy. Should he have done so, it would have, of course, created precedent that would risk crew members sort of blackmailing captains into giving them more money. It is accepted that the decision would likely be different if it was made in modern times. Because of the doctrine of economic duress, it would be difficult for such blackmail to be enforced in court. Now, a slight variation of this was created in Hartley and Ponsonby, where it was ruled that although Stilk and Merrick was still valid, they would be due the money if the situation created by the desertion of the crew changed their duties to an extent that they would not be bound to continue under the existing contract. Now, when you look at this case, of course, or these two cases, of course, we now must look at the case where we're considering a situation completely different from when you had Stilk, and that, of course, is Williams and Ruffy Brothers, a 1991 case which decided that in such situations the court will be quick to find consideration if practical benefits are given from one to another party. Now, if we just consider this exception to the rule in Stilk and Merrick for a moment, then you may see the extraordinary difference, arguably, that this provides. Now, in Williams and Ruffy Brothers and Nichols, the Court of Appeal recognizes consideration a factual advantage obtained by the promissor in addition to the legal advantage required in Stilk and Merrick. Now, Ruffy Brothers and the case there, I will go into the facts after we have had a break, but the point I want you to ponder as we go into the break is this. We know that normally when you're looking at the adequacy of consideration, that looks to a factual basis. Generally, when you're looking here, though, for the sufficiency of consideration, it tends to be a legal basis. What we're getting coming out of Ruffy, or what you will see we're getting coming out of Ruffy Brothers, is that we're using a factual basis in order to say that there is sufficient consideration. After the break, we will consider that some more in depth.